What's going on, y'all? Attorney Tom here. Today we're going to do another deposition react. This one comes by suggestion of the subreddit. The video is entitled Angry Lawyer Goes Off the Deep End. Should be good. And yes, before we begin, this is video number 3 where my mic stand is still broken. This just happened a few days ago. Give me some time. I'm gonna get a new mic stand, but for the meantime, I'm gonna be holding it like a stand-up comedian, I guess, because I'm very, very funny. Let's begin.
Questions I should ask. Will have your opportunity at the end.
Just shut up and move on with your questions, okay?
Mr. Curry.
Just shut up, or I'll adjourn this deposition, and you can tell it to the judge, or I'll get you some tissues and you can cry.
Mr. Curry.
All right?
The first thing I'm going to note is the cameras have gotten so much better since 2007. You can hardly even see this guy. It's all blurry. Being a lawyer means you're an advocate for your client. And being an advocate for your client often means you need to test the waters. You need to see how much you can get away with. And every opposing counsel has a different strike zone. Every opposing counsel has things that they are okay with and they aren't okay with. And these change. And part of being a good lawyer is finding that strike zone. But there's a huge difference between pushing the limit of what you can and can't do professionally and crossing the line to being unprofessional. You need to be able to professionally advocate and do your job effectively, but you leave the insults at the door. It's already totally inappropriate. Let's see where this goes.
Please don't tell me what to do.
You asked him if he ever spoke with Farsh about anything. He said no. Now you're asking him to tell you what Farsh told him. It is a bullshit question. It is absolutely speculative, no foundation or anything else. Now, he's entitled to a fair question. You told him that. So if you're going to sit there and ask unfair questions, I'm going to correct them. So I don't waste this guy's time having to come back or go to trial and undo the mess that you're trying to create. Got me?
Are you finished?
Are you finished?
So I understand what he was trying to say. Remember, in a deposition, you have limited objections. Generally, your only objections are objection form and objection foundation. And just because something is said in a deposition doesn't necessarily mean that it's going to be admitted into evidence. So, when a lawyer objects during a deposition, unless the lawyer instructs the client not to answer, generally the lawyer objects and then the deponent still answers the question. But if opposing counsel starts asking out of bounds questions repeatedly, oftentimes the lawyer needs to jump in and address opposing counsel and say, hey, opposing counsel, your line of questioning is out of bounds for XYZ reasons. You need to cut it out. What I'm trying to convey is there absolutely is gamesmanship. This is advocacy. There's a line, and that line called professionalism, between being an advocate and playing the game the right way and calling people names and being a jerk. This guy sounds like a jerk.
Are you
Do you understand the question,
Are
Mr.
you aware
Schiff?
of the local rules with regard to what objections you're allowed to make and what
Do you understand the question, Mr. Foster?
Sir, right now this is my witness. I get to ask the questions. You get to make objections only. There are 2 types of
Call the
objections
bailiff.
you can make. Objections
Call
to
the
form.
bailiff.
Sir.
Do you understand the question you're being asked, Mr.
Mr.
Foster?
Curry.
Don't ever presume that you get to tell me what to do or when to do it, counsel.
But that guy, Mr. Curry, is telling the other lawyer what to do.
Types of
Call the
objections
bailiff.
you can make. Objections
Call
to
the
form.
bailiff.
The lawyer who is taking the deposition is trying to remain focused on the deponent and say, hey, listen, all this sidebar, all this riffraff, you can make your objections. We'll deal with it later. But I'm going to ask my questions, and then we'll let the judge decide what is admitted, what's not admitted.
Don't you ever presume.
Why
Mr.
should you
Foster,
be
this is
entitled-
your deposition. Do you understand the question?
Why should you be entitled to then tell me what to do?
Yeah.
Doesn't it go both ways?
Good answer,
Because
Mr.
I'm being
Foster.
straight with the guy, and you're being not straight with the guy. That's why. He has no dog in this fight.
Are you finished giving your opinions now about...
He has no dog in this fight, says his lawyer. That logic ain't gonna fly.
No dog in this fight, and you're trying to get him to say things that are simply untrue. It's an old trick, Mr. Zohar.
Look at him chewing his
You're trying
gum.
to coach the witness right now.
I'm telling him what the question is.
He's trying
he can
so
answer.
hard not to smile.
Do you know what speaking objections are?
Don't lecture me, idiot. I'm telling you, I'm not gonna let that
Whoa.
happen. Okay? You got me? Do we
wanna
understand
know
each other?
if you understand the
Are we
rules.
connecting here? Because
I'm
if we're not
trying to
connecting
proceed.
here, I will try again. Okay? Don't give me local rules. Don't give me procedures. Don't give me professionalism. Just
This guy is such a dick. And he called Mr. Carter, I think his name was, an idiot. We are getting into sanctioned territory now.
don't lecture me, idiot. Put a fair question to the witness. And if you're not going to do that, then I am. We understand each other?
If you believe that a question that I ask is not proper, then you get to pose a valid objection. You're not allowed to make speaking objections. You're not allowed to give your
Don't lecture me,
opinions.
puppy. Don't lecture me. I was doing this when you were still chasing cheerleaders. Don't you even think about lecturing me about depositions.
I think you
I'm upset. I'm triggered. I hate that. I hate that. I knew it was going to come up. I didn't know it was going to come up, actually, but it makes sense now. Makes so much sense. Boomer lawyers think they know everything, and they will take advantage of you or try to take advantage of you just because you are young. And I know this from personal experience. Remember, I started my own law firm when I was 24 years old. You try rolling up to court or into a deposition when you are 24 and you're going up against a boomer. But you know what? That's fine, because then you kick their ass. And if you couldn't tell, I'm the kind of guy who thrives off of proving people wrong. I absolutely love it when I have an opposing counsel who is rude, because I will go out of my way to win, to prove myself. I love being a lawyer. This is awesome. Getting fired up.
practicing a few
So-
years more than me, actually.
so-
That's it,
so-
to be honest with you.
Do you understand the question?
Mr. Curry,
Let's have the question read
it is
back,
my
please.
desire to follow the rules. If you don't believe we should be following the rules, then maybe you need to explain to me what procedure we are supposed to follow.
Now, do you think that there's anything wrong with adding testmaster students who you met only by virtue of your employment at Testmaster?
Same case, different
to
depot,
a
I'm
prospective
assuming?
client file for your competing company?
That's Mr. Curry, all right. Same guy. Recognize his voice.
Object to the question is no foundation. It calls for speculation. Seeks a legal conclusion. It's argumentative, and I'm instructing the witness not to answer.
Mr. Tatey, do you think that it would be improper for you to copy your employer's course material while you're a Testmaster's instructor and use it for a competing business?
Same objections, same instruction.
So as we sit here today, you don't know whether or not it's a true statement that as of March 30th, 2005, Blueprint had not yet finished the writing and production of its LSAT course.
Objection, argumentative, also invades the attorney-client privilege and the work product doctrine, instructed not to answer.
Whoa.
Do you deny, Mr. Tatey, that as of January 12th of 2005, that Matt Riley was a Blueprint partner?
Objection, same objections, same instruction.
Okay, so this clearly is a case about stealing some sort of coursework material. I'm assuming, oh my gosh, I kind of paused this at a great time. Look at this guy's face. He is pissed. You're allowed to find out a lot in a deposition. It is discovery. And if a lawyer continuously instructs their client not to answer, citing attorney-client privilege, nothing really gets discovered. So what's going to end up happening is the guy taking the deposition is going to go to the judge and say, Mr. Curry instructed the client not to answer any of my questions. We need to take this deposition again. And then the parties are going to have to spend more time and more money doing another deposition just so this guy can answer the questions that he should have answered the first time. Now, I'm not saying that it is never proper to instruct your client not to answer questions. We do that. But I can see the pattern just based off of these jump cuts. This guy isn't answering anything.
Mr. Curry, this goes to the very heart of the case here, and I'd ask you to reconsider your instruction and allow Mr. Tate, to answer this very simple fundamental question.
There you go.
I've reconsidered. The answer is no.
Can you rule out the possibility
I want to listen to that again.
here? And I'd ask you to reconsider your instruction and allow Mr. Tate to answer this very simple fundamental question.
I've reconsidered. The answer is no.
Can you rule out the possibility that Matthew Riley was a Blueprint partner while he was still teaching for test masters?
Same objection, same instruction.
Do you deny that Matthew Riley was a Blueprint partner at the same time that he was teaching test masters classes?
Same objection, same instruction.
Do you deny that Matt Riley was working on the Blueprint website while he was still teaching classes for test masters?
Objection, it's argumentative, calls for speculation, there's no foundation, instruct the witness not to answer.
And can you say with certainty that Mr. McCarthy did not help in any way in helping Blueprint create the course material?
Objection, calls for speculation, no foundation, it's argumentative, instruct the witness.
This guy has firsthand knowledge. He's probably a party to this lawsuit, and this is a deposition. These questions seem totally in bounds.
Not to answer.
Do you deny that Courtney Martin was working for Blueprint on its website while she was a test masters instructor?
Objection. Same objection, same instruction.
Were you trying to get Courtney Martin to do work for Blueprint while she was a test masters employee?
Objection, vague and ambiguous. You can answer if you understand the question.
Objection, vague and ambiguous. It's not a thing.
I don't believe that I was.
Do you deny that you were?
Objection, Ashton answered. Argumentative, no foundation, calls for speculation, instruct the witness not to answer.
Now, why around this time period did you want to damage Robin Singh?
Objection, calls for speculation, no foundation, it's argumentative, instruct him not to answer as phrased. Okay, that's it.
It's like correction, just because I'm a lawyer. When I meant that objecting because a question is vague isn't a thing, I meant that specific question. That was not a very vague question. Pretty not vague. Move on.
Move on.
This guy kind of looks like Ted Mosby from How I Met Your Mother.
Well, let me.
No, we're done.
Okay, that's fine. I'm not asking any more questions. I want to make a record here, if I may, Mr. Curry. I think that your instructions not to answer numerous questions are improper and unfortunate, particularly in light of these new documents that were just discovered. The judges repeatedly suggested that we should. There's a likelihood of having follow-on discovery after e-discovery. I think that it's improper, and I think that you're obstructing our ability to get to the bottom of these critical and highly damaging documents. And I'd like to put you on notice that if you don't allow us to continue to ask questions now or at a subsequent time, that we believe that you will be obstructing our ability to obtain evidence about improper discovery abuses by your client, and that you will be aiding and abetting in those discovery abuses. And I ask you to reconsider and permit us to ask Mr. Tate these questions.
Take your threats and put them where you know better.
I'm not making threats.
Yes, you are. Just tell it to somebody here.
Ending with a bang. So it was very important that the lawyer said that on the record at the very end. He wouldn't let Mr. Curry leave until he got that little notice on the record. At the very end, they just came out and said, we cannot conduct a full deposition today because Mr. Curry has been instructing the witness not to answer any questions. We have been unable to get to the heart of the matter because of these instructions. We asked counsel to reconsider his instructions so we can do the deposition right now, right here, while we are still in this room and we don't have to come back. If I was willing to bet, they probably did that guy's deposition again. And Mr. Curry told the other lawyer to go shove his questions up his ass. All right, interesting video. Oh yeah, that's it for today's video. I hope you reconsider subscribing.
I've reconsidered.
Thank you very much. I know you did. Oh yeah, that's it for today's video. Make sure you consider subscribing to this channel and hit that like button if you want to be a part of this community. Leave any questions, comments, concerns down below. We're growing like crazy. I think we just passed 370,000 subscribers. All right, y'all. Thank you so much for watching. Talk to you soon. Bye.